SJC-11863, Randall Trapp versus Commissioner of Department of Corrections.
Excuse me one second. Okay. Okay, Mr. McFarland, when you're appropriately hydrated, you can begin.
Your Honor, good morning. May it please the court, Richard McFarland on behalf of the Department of Correction defendants, Harold Clark, Cynthia Sumner, and Gary Roden. This case started out with a 2003 settlement agreement between 5 Native American inmates with the Department of Correction. That provided for Native American sweat lodges for 3 facilities. In 2010, plaintiff Randall Trapp filed a lawsuit alleging a breach of that settlement agreement. He then added Robert Ferreira became a defendant, a plaintiff also in the amended complaint. We had a jury trial in July of 2012. A decision from the judge in September 26, 2012. Now, the judge's decision focused on 3 issues: the plaintiff's access to tobacco for Native American smudging and sweat lodge ceremonies, the discontinuation of the sweat lodge ceremonies at MCI in Norfolk and Sousa Baranowski Correctional Center, and the DOC's policy limiting the plaintiffs to certain colors for prayer beads. The issues were reviewed by the lower court on challenges by the plaintiffs under the settlement agreement, RLUIPA, the First Amendment, and Article 2 of the Mass Declaration of Rights. The lower court in this decision determined that the DOC policies with regard to the settlement, with regard to the tobacco access, discontinuation of the sweat lodges, and the prayer beads did not violate the First Amendment. The lower court also held that the policy prohibiting the plaintiffs from smoking the kinnick with tobacco indoors at MCI Norfolk created a security concern, and thus held that that policy did not violate RLUIPA or Article 2.
With respect to the prayer beads, did the inmates desire to take the prayer beads back to their cells with them?
Yes, they were personal property items.
Okay. Was there any possibility of issuing them the colored prayer beads with the yellow, the blue, and the red, but collecting them after the ceremony ended, or were they used for religious purposes beyond just a ceremony?
I think the several other groups, religious groups, also would carry prayer beads with them and would wear them. So the rosary beads for the Catholic inmates sometimes. So the policy was to allow that to be a personal item, religious item, to be kept in one's cell.
Okay, so was there any consideration given to allowing them to use the fully colored prayer beads during a religious ceremony, but collecting them after the ceremony ended, so that they couldn't take them back to their cell?
That was not considered, Your Honor, as far as I know.
Was it requested?
No, the inmates in the suit wanted to have yellow, red, green, the colors that they wanted, and did not want to
In their
accept.
cells?
In their cells.
Okay.
On their persons.
Okay, if we can turn to the Sousa Baranowski Purification Lodge. Do you agree, in light of the U.S. Supreme Court case of Holt versus Hobbs, that it was a substantial burden to deny them the opportunity to have that purification ceremony?
Yes, we would agree that that recent Supreme Court case does seem to foreclose a consideration of the other religious items that are activities that are provided to religious groups.
Okay, so we have a substantial burden. Your argument, I'm sure, is that the health of the inmates and the staff is a compelling government interest, correct?
Correct.
But the judge made factual findings that said that he was not persuaded that the least restrictive alternative was to have no fires. Isn't the issue as to whether the judge was clearly erroneous in making that finding?
Well, it's also how they applied it. The judge's findings of fact in the first part of the decision also did agree that there was excessive amount of smoke that was going into the facility and that inmates and staff who were asthmatic were being affected by that.
But was part of the, was there any evidence in terms of the cost of, because he mentioned something about filtering the air, or was there any evidence in terms of the cost
No,
of
there
that?
was no evidence about, we did have our engineer testify, Mr. Grundlock testified, and he was very familiar with heating and air conditioning. He did not testify that by getting a special type of filters that would have made a difference.
Did he testify it wouldn't have made a difference, or he just didn't talk
He didn't talk about that, but he did talk about the fact that there was, whenever the smoke would come in, based on the type of system that it was a closed ventilation system, which would bring all the air in, that there was no way that they could prevent that smoke from coming in and filtering into the rest of the prison. But he did not address, no one asked him, or did the court ask him, if there was a new brand of filters which may be available to avoid that problem.
Whose burden was it to make that showing?
Well, we had the burden to show our compelling interest, and we presented the testimony of the director of treatment, who talked about the fact that when they did the test fires, the smoke got into the institution, and a number of staff and inmates were complaining about the distressing effects of the smoke.
Didn't you also have the burden to show the least restrictive alternative, that shutting it down was the least restrictive alternative?
We did 3 different test fires in different locations. They had hired an outside consulting firm, and we did do 3 test fires at different places in the hopes that a different location farther away from the prisons and the ventilation system would be sufficient to avoid the smoke, but that was not the case.
Which is the part that is holy, the heated rocks or the heating of rocks by wood fires?
I think it's all of that, all the above, Your Honor. I think that they dig a pit outside of the sweat lodge and use wood fire to heat the rocks to a certain temperature, and it takes 3 to 4 hours to get them to the right temperature. And then there's a fire tender, a inmate who serves as the fire tender, who watches the fire as part of the ceremony. And that person then takes the heated rocks and places them inside the pit, inside the sweat lodge, which is covered with tarps and blankets and things.
But doesn't the agreement require consultation with the Massachusetts Commission on Indian Affairs before doing anything? And wouldn't that have been a way of showing that you tried but could not come up with the least restrictive alternative that would be all right? Because, I mean, isn't it possible to heat the stones other than by a wood fire? And you don't know that because you didn't do it.
Well, yes, the consultation was very limited if it all existed, but I think the problem we were having is that in order to keep starting the fires, each time we would have that issue of the smoke coming in.
Why, if you didn't use a heat
If you didn't,
like wood?
well, we had to use wood, and they had to use a special
do you
type
have
of.
to use wood?
Well, that was a tradition for the.
I know that, but you didn't consult to see if there was an alternative to it. And aren't there prisons throughout the country who successfully do this?
Yes, and we do it in our Gardner facility, but there's no issue of the ventilation systems.
Right, but you may have to do it differently in different facilities.
Correct, but I mean, in this situation, the smoke was very, very pungent, and there was no area to place the fire within the prison itself. And, they do require that certain types of rocks are used within the sweat lodges to create the heat. and the wood fire was part of the plan.
But,
So could you help me? I'm sorry, Justice
no, I'm
Ling.
just saying, how do you know that that was something that there could be no alternative to?
We didn't know for sure, but we looked at other alternatives, but
Right, okay.
My question, if you could, are you pressing your argument that you made at the end of your brief that this issue is not properly, was not properly raised before the trial judge because of the narrowness of the amended complaint?
well, yes, Your Honor. I mean, the case had been going on since 2010, and then right before trial is when the plaintiff Ferreira was transferred from Norfolk. He'd been in MTA Norfolk along with Mr. Trapp for many, many years. And at that point, they opened up the issue of the sweat lodge in Sousa Baranowski, but never amended the complaint to include that or add any defendants from Sousa Baranowski Correctional Center.
Well, did they have to do that where this policy comes from the top and not really the superintendent of that facility? And it was part of the settlement agreement.
Well, it was part of the settlement agreement, but there were areas where we could make changes based on safety and security.
Yeah, but this change was based on health, not security.
Well, we would disagree with that. We think that health of inmates.
But you said at the trial, you didn't say security, you said health.
Well, yes, but we would say that health of inmates and staff goes part and parcel with security. And we cite in our briefs a number of cases where courts have upheld prison policies which limit environmental issues. In fact, many cases where Native American inmates wanted to smoke tobacco with kinnick in their cells. And because of the secondhand smoke and the ventilation systems, courts were approved the policies which limited those indoor smoking. There are a number of, then we also have the Helling case involving the Eighth Amendment, which places the burden on prisons to, under the Eighth Amendment, to provide for their health and safety. And that case involved secondhand smoke that was from inmates who were smoking, who were infecting other inmates who didn't smoke, and that created.
Sorry, I didn't hear your answer. Are you pressing your claim that this issue was not properly raised in the trial court?
Yes, Your Honor. We're saying that they should have amended the complaint to include Mr. Ferreira's access to
Well, did you object to the judge's consideration of it?
We objected at trial, and then we objected in our reconsideration motion.
You objected to the judge's review of this issue?
We objected to the introduction
I
of.
looked at the transcript and I didn't see that.
I believe we objected to the introduction of the evidence on the Sousa Baranowski sweat lodge.
Okay.
Now, the settlement agreement was not a class action, I gather.
Correct.
And what is your position as to its consequence here? That it's irrelevant because these were not among the four parties to it?
Well, no, the settlement agreement is still in effect, and we have facilities. Right now, we have one at Shirley and at Norfolk and at Gardner.
Is it your view that Mr. Trapp cannot seek to enforce it?
He can enforce it, but our point was that Mr. Trapp had never been at Sousa Baranowski, and but for the transfer of Mr. Ferreira to Sousa Baranowski, the issue wouldn't have been part of the trial.
So the point is, I'm sorry, Mr. Ferreira is not a party to this
He
appeal?
was not a party to this. That was the decision of the lower court in the motion to dismiss found that Mr. Ferreira was not a party to the settlement agreement. He was not a intended beneficiary.
Because he came later?
Because he came later and he also did, he wasn't part of the original 5 inmates, and he also failed to, the court found that he'd failed to exhaust his remedies under the PLRA.
But I'm a little bit perplexed. You enter into the settlement agreement, and is it the view that it would not apply to others who also hold the same faith?
Well, no, others were allowed to participate, but the settlement agreement was not intended to make them beneficiaries of the
So
agreement.
that goes back to my other question, then who can enforce it? There is a breach of it, who can enforce it?
The inmates who were part of that,
Just those.
yes, sir.
So
Mr.
you
Honor.
could ignore it and only those 4 people can complain?
That was the agreement, Your Honor. It's-
That, you mean, so even though the agreement may deal with Sousa Baranowski, if those 4 get transferred out, it doesn't matter anymore, and you can just say, too bad?
Well, we've created the sweat lodges throughout the facility, throughout a number of facilities, so those are still in place. But to actually bring an action in contract to enforce the settlement agreement would have to be one of the plaintiffs.
So, but they could, quite apart from the settlement agreement, I take it that an inmate at Sousa Baranowski who claimed that his religion required a sweat lodge or purification ceremonies could bring the same suit.
Exactly, and that
Just a
that
question
has
of whether
happened.
you have a right under the settlement agreement.
Correct, and that has happened.
Okay. I don't remember what I was going to ask.
Okay, thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Jared Scarpese for the appellees Randall Trapp and Robert Ferrara. Just to start off on this argument is that my brother counsel is saying that the RLUIPA didn't apply to Robert Ferrara in the Sousa Baranowski. I mean, in this case, as all of you were talking about, especially you, Justice Lang, is that the fact is that, yes, you know what, there was a burden put on this. They took away the sweat lodge.
I don't think he was saying that RLUIPA didn't. It was at the settlement agreement as a cause of action.
Well, he's saying that they used alternative means, like the 3 test fires. However, in this case, as you were saying before, is that he was saying that it was health concerns. Throughout this entire, through the lower court decision, there's never been one reported health concerns. There's been, like the judge said in the lower trial court opinion, is that these were just hearsay statements made from Lynn Charnowski. She was one of the director of treatments that testified at the trial that none of these were, they were just hearsay statements.
In his decision, the judge makes reference to the settlement agreement as containing, quote, written protocols entitled Protocols for the Construction and Operation of Native American Purification Lodges within the Massachusetts Department of Correction, detailing the manner by which lodges were to be constructed and the ceremonies conducted. Was that limited to just the 5 inmates at the time, or was it intended to be an agreement that covered a system-wide
No,
protocol?
so, well, in the settlement agreement, it only says for 3 purification lodges, so at Sousa Baranowski, Norfolk, and then Gardner. However, also in the settlement agreement, it states that anybody that actively participates in these can enjoy the settlement lodges or participate in the settlement lodges. So, like, going back to your question at that point, is that it would only be around those 3 specific prisons that they had the purification lodges at.
So if I was in Plymouth, I couldn't access.
At this point, no. So the only time they have purification lodges is at Gardner, Sousa Baranowski, and Norfolk. I know that from what I've been told from other prisoners that they do have circles. So they go and they
smudge.
They smudge, they pray, they are able to talk to it's called a talking stick, whereas it's opening up their gods. They don't have a sweat lodge at those prisons, though.
Well, are you suggesting, that the most recent U.S. Supreme Court would require sweat lodges now at all places where there would be?
I think at this point in time, yes, I'm fine with that because.
Well, you're fine with that, but I'm saying, do you think that now is the
law?
law?
I think that's another argument for another time. I think that it would obviously have to be grieved upon because obviously there's certain protocols, obviously, to exhaust their remedies at certain prisons is that they have to grieve about this, and then obviously they would file suit for this. In this case, it's kind of a little different. They have twofold. They have the RLUIPA, and then as the settlement agreement in this case is that the Department of Corrections under the settlement agreement, if they're going to alter or amend, and my clients understand that for security purposes, obviously that this is a big thing. A sweat lodge is, if I can show a demonstration, is that the sweat lodge is right here, there's a path, and my brother was counsel was saying is that there's the wood that's heated up at the end. There's a gentleman that watches the wood, goes down the path back into the sweat lodge, and then they have their ceremonies. I mean,
So we couldn't heat these rocks with microwaves or something. Wood is part of the
Well,
ceremony.
the thing is that I wish it would be that simple. I've spent 4 years now learning about this Native American religion. I mean, I'm not that very religious at all, but I've tried to figure out other alternatives to assist that how this can be done. The method is pretty sacred. It's Native American religion is almost, they don't want it to come about. It's a sacred process rather than like the Catholic, the Jewish, or Wicca, or any other religions they have. It's a very sacred religion. So the alternatives, I mean, yeah, it would, obviously they have to use alternatives under RLUIPA as well as consultation with the Massachusetts Indian and Bureau of Affairs. They didn't do that in this case, and I think that if they did, they would have showed, okay, you know what, we have limited space at these prisons. We could do it this way. And my clients in this case would probably accept that. I mean, yeah, they'd probably get a little bit angry, but I mean, we got to kind of give and take in this situation because you are at a prison and obviously you have other matters to worry about. That was never considered in this matter.
Let me just ask, if the facts did plainly demonstrate that any wood fire on the Sousa Baranowski property would get into the facility and pose a health risk to staff and inmates, would you agree that that would bar the use of those fires for these lodges?
No, because under the Holt case, I think that they could use, I mean, as they came down and said that monetary alternative means could be used to try to create this. I mean, I think that they just did 3 test fires. I mean, that would be a story almost for another day, is that if they choose other alternatives and they came down to the fact that, listen, we can't do anything whatsoever different because all the smoke would enter the facility and obviously would harm people, I think that would be another question, but I don't think that was done.
Would you say that let's say they put in evidence that this really does, it wasn't hearsay, I mean, it really does affect the health, and they also put in evidence that to change the ventilation system would be an astronomical expense. Does the judge get to say, I don't think it's so expensive, you got to do it?
No, not necessarily, because I think that obviously you'd have to come to a reasoning is that, okay, you know what, is it going to be astronomical? Is there complaints? I mean, this time, they stopped the lodge in 2010, and there's been no complaints whatsoever when they did all the test fires or anything of that nature. So that's kind of a moot point, is that never happened. It never existed. Secondly, is with the monetary, I mean, that's another thing. I mean, the whole case just came down in May, and they said that you have to use monetary. I mean, do I know how much it is? I can't put a figure to that.
So let me make sure I understand. Are you saying that if push came to shove and it turned out that the wood fires were going to provide too severe a health hazard, that your argument would be then you should go to Bureau of Indian Affairs and they should explore the possibility of saying you can't have a purification lodge with a wood fire, but you can have it if it's to be heated, say, by a propane grill?
I agree with that. I mean, on my part, I agree with that. Obviously, I'd have to speak with my clients to see what their reasonings were, but I think in this case is that, yes, I mean, if you want to practice your religion, and I understand that you're in a prison and there's obviously hundreds of other members, you're going to have to obviously adjust your situation at that time. I mean, you can't harm other members just so that you can pray. I mean, they're still giving you the opportunity to pray, and yeah, it might be a sidestep from what the traditional is, but you have to think of where you are. And to go back on what you said is that even if they prove the test fires, I think that they should consult with the Massachusetts on Indian Affairs and see what other alternatives are, not just go do the test fires and not talk with them, because that's what they did last time, and they never consulted with them. I mean, I'll give him the benefit of doubt. They had a gentleman, his name is Paul Pullo. He was leading the sweat lodges at that time. Yeah, he was out there, but you know what? He doesn't do alternative things. He doesn't know the other means. He doesn't know if they could. I mean, Sousa Baranowski is a big yard. I mean, it's a very big prison if you've ever been there. Yes. I think that they could go to different areas. I was never around during the first trial period. I was I was still in high school at that time. But I think that they could go to different areas and try to do different things. I mean, that's what the settlement agreement says, that's what RLUIPA says. So you had 2 chances here, and you didn't do it at either time.
What's the story with the lack of a volunteer to be able to,
So this is another thing that I run into every single time. I'm assuming that you got the letter from Randall Trapp. It's a tough situation, is that, so they had a gentleman in 2010, his name was James Raven Farnham. He got suspended for, obviously, the Department of Correction policies. He then reapplied, and they said, listen, what you did was obviously damaging, so we can't let you back in. They had another gentleman come from Lenox, Mass. He goes to Gardner, but obviously Gardner's a little close to Lenox, Mass than actually Sousa Baranowski is in Shirley, or Norfolk is in Norfolk. They had another gentleman, short period, he got suspended and he's not there anymore. From what I've been told by Randall Trapp is that there's a reverend, and that I believe is in the Catholic religion, is that he's willing to conduct these ceremonies at this point in time. But that's the holdup, is that, yeah, if you justices say, yes, you know what, we agree with both the appellees in this case, but now we have to go back to the twofold, is that now they have that double-edged sword that says, we can't find a volunteer, so you can't have your sweat lodges, which I understand, because obviously it's for security purposes. You can't have, 10 to 12 prisoners doing the ceremony, I mean, obviously for security purposes. But it's difficult because they had Raven Farnham, came with his own money from Orange, Massachusetts. I went out to his house. I mean, Orange is 2 hours from here, to talk to him. And he wanted to come back on his own money, but obviously the Department of Corrections said that he couldn't because they have certain policies. I mean, I think in this case, I think that we should review of what he did and then take a look at it, because you have a gentleman that's willing to come back on his own penny.
But we don't, so Norfolk, there's no, but that's not
No, it's
before
not-
us,
no,
right?
No, I just wanted to present you
Yeah,
that. I mean,
no,
it's kind of,
right.
it's a complex situation.
Now, are you challenging the color beads here?
No, not at, I mean, I'm going to put forth the argument and say, yes, I'll challenge them, but obviously my clients understand is that the color beads are a difficult situation to have in your prison.
Okay,
because-
but I mean, bottom line, are we supposed to rule on the color beads and the
No.
tobacco issue, or are we
Well,
supposed
yes,
to rule only on
I'll-
Sousa Baranowski?
Yep, so on the tobacco and the, yes, so the tobacco thing, yes, you're supposed to rule on, because.
Cross appeal?
No. But that wasn't on, if you're talking about it, that wasn't on for appeal. The tobacco was, the beads were not.
Okay. Now, with regard, I'm trying to sort out what your argument is with regard to least restrictive alternative. It sounds as if what you are saying is that to examine whether this is the least restrictive alternative to bar it, you would have to explore not only the potential to have other fires in different locations and fans and other things, but you'd also have to explore the possibility of some compromise by the inmates themselves to tradition in order to say, we would rather make this compromise in order to spare the ceremony than not. I mean, is that your position?
That's my position, because the ceremony, it only happens once a month, and there's a 13-month solstice in the Native American, and I think to pull away completely that lodge, they're not able to pray.
Okay, so you're saying that even if there were no place where the fires could be safely done, the obligation would be to say, maybe there's some alternative to heating the stones that would avoid this problem and may not be entirely in keeping with the tradition, but would still be better than not having the ceremony.
That is correct.
In the absence of further questions, thank you.
Thank you.